Hi, everyone. This is Tom Sullivan. I'm here with my colleague, Andy Trask, and we're presenting today the next installment of Class Action Quick Hits. And today we're going to talk about settlement tips. There is a lot happening in the settlement context in class actions these days. This presentation won't cover all of it, but we're going to cover a couple of new cases that present some interesting issues and should give you some food for thought going forward if you settle a class action. Andy, do you want to take it away with the first case?
Sure thing. So our first case is Chambers versus Whirlpool Corporation, which was decided at the end of 2020 in the Ninth Circuit. This was a long-running class action involving allegations of consumer fraud and breach of warranty surrounding malfunctioning dishwashers. It's one of those class actions that is essentially a products liability class action, although for certification purposes, there are no actual product liability claims in the case itself. That's going to become significant in a moment. Ultimately, it wound up settling. The plaintiffs wound up settling with the defendants for either, and this is the part that the court got very confused by, either $4.2 million or $114 million, but in either case with $14.8 million in fees. And so the question that the court was faced with, both below in the Central District of California and above at the Ninth Circuit, was how does one value this particular class action? The defendants had been arguing that you essentially value it at $4.2 million, and the objectors made that argument as well, because how much of the class action itself was done with rebates to various class members, all of which were to buy new Whirlpool dishwashers to replace the ones that allegedly malfunctioned. Incidentally, this is one of those cases where the actual malfunction rate was roughly 1% of the dishwashers. 99% were simply deemed to be defective because they had the same components, even though those components never went wrong during the life of the dishwasher. The plaintiffs claimed that because these were because these allowed people to buy new dishwashers, they could value that particular relief at about $114 million, which made their $14 million fee request seem like a reasonable percentage and certainly a decent lodestar. The objectors came in and essentially said, if we look at the redemption rate for the relief that was offered, only enough people bought new dishwashers using this relief to amount for $4.2 million of relief overall, at which point $14.8 million in settlement request begins to look a lot like 3 times the amount that went to the class and an outrageous lodestar for the result that was provided. So the district or the Ninth Circuit had to sit down and determine whether or not these rebate offers were coupons under CAFA or some other form of injunctive or equitable relief under the rules. And what the court determined was that these were basically coupons. They weren't transferable to anybody else. You had to go back to the manufacturer you were suing to get another product from them, which essentially purchase. And those are the essential elements of a coupon settlement under CAFA. And coupon settlements under CAFA mean that the attorney's fees have to be calculated as a portion of the settlement that's or a portion of the actual recovery of the settlement. In this particular case, what the Central District had done was to determine that it wasn't entirely sure what the ultimate amount would be. It was bifurcating the settlement, and it determined a large amount of it on lodestar, just on how much the attorneys had actually spent, and it offered a 1.68 multiplier for that, given the risk involved. The Ninth Circuit said there was no reason for any multiplier whatsoever, no matter how hard anybody that it was ultimately the amount that ultimately came back, and that given the fact that it was coupons, it should have all been determined on a percentage of the amount actually recovered. As a result, the Ninth Circuit affirmed the settlement overall, but it slashed the attorney's fees, or remanded in order to slash the attorney's fees based on the fact that these were coupons. And so ultimately, it was the fee award that was modified while the settlement itself was allowed to go forward. So the lesson here is, if it looks like a coupon, spends like a coupon, and gets you only a discount on the manufacturer's products like a coupon, it's a coupon. And no matter what else you wind up calling it, a voucher, a rebate, a guilt-induced payment, it's ultimately going to be treated as a coupon on CAFA. Tom, do you want to go on to the next one?
Sure. Thanks, Andy. The next case is another interesting settlement decision. This is Bereni versus Barilla, 964 F. 3rd 141, Second Circuit. And as a class action defense lawyer, I try to stay mindful that Rule 23 has often been used for a lot of positive things, such as in civil rights cases, for example. Here, the B2 class action was not such a case. This was used in this case to pursue an allegedly underfilled pasta box. So the named plaintiff filed suit against Barilla, alleging that his pasta box was underfilled and that he received less pasta than he thought he might otherwise have received if it had been filled to the top. And what happened in this case is that the parties negotiated a fairly quick settlement, and there was an objection filed by Attorney Schulman. And Attorney Schulman objected specifically to two aspects of the settlement that were a component of the injunctive relief of the settlement. One was that there was a disclaimer that was now included on the package as a result of the settlement about the amount of pasta used filled in the box. And second, there was a fill line included on the box going forward to identify for customers where they could expect to have the box filled to. The problem here is that injunctive relief is typically used only to prevent against the likelihood of future harm. And here, the Second Circuit found this was not the class members who had already been injured did not have the ability to pursue the B2 class because there was no likelihood that they would be harmed in the future. The reason, of course, is that they would not be fooled by the amount of pasta in the box any longer. And therefore, there were some class members for whom this might be appropriate relief, but a subgroup of those class members for whom it would not. And that was exactly objector Schulman's point. And as a result, the court vacated the settlement and remanded the case to the district court for further consideration. So keep in mind, this case is important to keep in mind that when you're settling a B2 class, you need to target the injunctive nature of the relief to class members who will likely be injured in the future. And it can't be used on behalf of class members who stand not to be harmed going forward. Andy, do you want to go ahead with the Johnson case?
Yes, our final case of the three that we're covering today is Johnson versus NPAS Solutions, LLC. Now, this is a TCPA class action. And for those of you who may not be familiar with that, the TCPA is the Telecommunications Protection Act, Telecommunications Consumer Protection Act. And it basically covers unwanted telecommunications to various consumers, unwanted texts and unwanted faxes primarily. As a result, it offers a $500 statutory award for every violation, which means that class actions, which may collect thousands, if not millions of violations with some unscrupulous marketers, can sometimes be worth in the millions to tens of millions to hundreds of millions of dollars, at least on their face. They often settle quickly. They're often brought by repeat player firms. Those firms are often criticized for the tactics that they bring in and the various ways in which they move towards settlement quickly. So a lot of TCPA opinions do result in significant class action opinions ultimately. In this particular case, the 11th Circuit took the opportunity to issue two very important holdings. The first and foremost of these is that in this particular case, or not the first and foremost, but the first of these is that in this particular case, the plaintiffs and the defendants wound up settling very quickly, and the settlement objection date was held before the announcement of what the fees would be. Under Rule 23H, that's not supposed to happen, and it's a real problem for class action objectors in particular, because it means that when you object to a settlement, you don't know whether or not the attorney's fees that are being paid out are disproportionate to the relief. Some settlements may appear to be objectionable if an attorney's collecting millions of dollars in fees, but not so much if they're taking a haircut and only getting a couple of $100,000 in comparison to several million to the plaintiffs or to the class members overall. But you can't tell that until you've seen the fee request. And so there are a number of courts around the country that have at various times criticized the timing of some class action settlement objections. Or at least the deadline for those objections. In this particular case, the 11th Circuit came out and very clearly said that if you require objections before the fee petition has been put into play, then you violated Rule 23H. Although in this particular case, that wound up being a harmless objection because the fee was more in line with what it was supposed to be anyway. But still, that statement that 23H is in fact binding and does in fact have teeth is something that class action litigators should pay attention to. On the defense side, it becomes very important because if you're trying to objector-proof your settlement by making it as legitimate as possible, you have to be clear about the timing of when objections are allowed versus when your adversary is going to request their fees. The second thing, and the one that is far more interesting and potentially important going forward, is that there is a longstanding practice in almost every circuit of at the end of a class action, either adversarial or one that settles, you usually wind up paying each of the named plaintiffs some small amount of money that essentially reflects the time and effort that they put into the case. These are often referred to as incentive awards. They usually range from somewhere between $5,000 to $10,000, although there have been cases in which they've gone up to $1 million and lots of cases in which they're much smaller. But in general, most courts have allowed them. In this particular case, the 11th Circuit looked at of incentive awards and the history of paying litigants in general to bring cases and held that Supreme Court precedent does not allow for either salaries or bounties for bringing litigation. And specifically said that in this particular case, the incentive award that Johnson seeks, it seems to us, is part salary and part bounty, both prohibited by Supreme Court precedent. So it vacated and remanded the settlement to essentially relook at the fees and to eliminate the objector award, or not the objector awards, but the incentive awards to the named plaintiff. Now, this is critically important because this is a brand new quiver or brand new arrow in the quiver of various objectors. It's not only going to be limited to the 11th Circuit. In fact, going forward from here, it's going to be brought up in other circuits as well. To this date, and I've listed one of the cases, which is the first one, but we've also got several at other circuits now, there have been objections in the 11th Circuit, which have been upheld, but also in the 3rd, the 8th, and the 9th Circuits to various settlements on the basis that that fees to the named plaintiffs are not allowed because they are illegal bounties or salaries. The 3rd Circuit, the 8th Circuit, and the 9th Circuit have all declined to follow Johnson so far. The 3rd Circuit's logic, which was the first one, basically goes with what it's supposed to be, or what the other circuits have gone with, which is there's substantial precedent in each of those circuits to allow for incentive awards. And so the question of whether or not an 1876 Supreme Court precedent, and that is how far back the 11th Circuit went, can displace modern precedent on this. What that means is that we're likely to see a developing circuit split. The 11th Circuit so far does not look like it's going to back off of this position. It looks like a number of other courts are probably going to take the opposing side of it. And my guess is that at some point, somebody will bring this up to the Supreme Court to see whether or not incentive awards are in fact legitimate. Until that time, if you are in the 11th Circuit, don't agree to incentive awards because you're likely to draw objections. Outside of the 11th Circuit, make sure that there is precedent post-dating Johnson that allows for incentive awards in your circuit. And if there's not, at the very least, be certain that you think that your judge is going to uphold it. And with that, we're going to look at a couple of more things that are just general settlement tips to remember, but may not be late-breaking news, to make sure that you're still doing an adequate job of keeping up with the state of the art. And Tom is going to handle that.
Thanks, Andy. And just listening to you talk and looking at these three cases we've talked about today, perhaps the first bullet point on this slide should be know your circuit law, know which circuit you're in, because there are a lot of changes taking place on a lot of these issues. So it's critically important when settling a class action, even before that, to understand what the law is that will govern the settlement and where the points are that an objector may attack. So that's probably the most important thing. Just a couple of other watch outs. Be careful about side prey distributions. Those have drawn attention from objectors in courts. Avoid reversions where possible. And one that I always have to keep in mind when jurisdiction of the class action is based on CAFA, make sure your settlement administrator handles the CAFA notice, because that has important implications for the finality of the settlement and is a detail that can be easily forgotten. So just a couple of watch outs there, but in wrapping up, I think it's important just to keep in mind that the law of class action settlements is changing frequently. It's a dynamic area of Rule 23 practice, and there are a number of things to keep in mind. So hopefully this was helpful to you all, and we'll be back soon with another episode of Class Action Quick Hits. Thanks so much, Andy.
Thank you, Tom. Always a pleasure.